We're now here, ex parte Amarillyz Estevez, PD-0581-24 from Harris County. Please approach. And please state your name when you start your argument.
Thank you. Good afternoon. My name is Mark Bennett, and on behalf of the Institute for Advanced Criminal Law Studies, I represent Amarillyz Estevez. I want to talk about the rule of decision in this case. The rule of decision in this case is that the state cannot wire around a federal constitutional requirement with a state procedural law. Let me give you the absurd example. The state writes a law, in fact, the people pass a constitutional amendment that says that an indictment or information gives the trial court jurisdiction over the cause, but only if the judge is wearing a red bow tie. Ms. Estevez is accused of contempt, and she goes in for her hearing, and the state puts on its evidence, and Ms. Estevez's lawyer says, hold on a moment, Your Honor, I observe that you're not wearing a red bow tie. You violated the red bow tie requirement. And the judge says, that's fine, that's fine. I'll put on a red bow tie. I don't have one with me. We'll come back in 3 days or a week or so. Your client's going to sit in jail until then, but we can do that. We can follow the red bow tie law. Lawyer says, no, that's fine, Your Honor. We'll go forward today. The judge holds Ms. Estevez in contempt. Ms. Estevez, and this is a deviation from the facts in our current case, but imagine that Ms. Estevez then files an application for writ of habeas corpus, which is the only appeal, of course, from a contempt, there being no direct appeal. Ms. Estevez files an application for writ of habeas corpus, and eventually it makes its way to this court. This court says, what? This court says that Ms. Estevez says, my judgment was void because the judge wasn't wearing a red bow tie. And this court, I suspect, says, you waived that. You invited that error. Okay, so Ms. Estevez is still in jail, and now the state wants to prosecute Ms. Estevez for the DWI that was the alleged contempt. And now Ms. Estevez says, well, there's this contempt judgment against me, and it was with a red bow tie, but I waived that, and that should stop me from being prosecuted for the contempt. What does the court say then? The state knew about the lack of a red bow tie. They knew about that at the hearing because Ms. Estevez's lawyer at the time had objected. They didn't do anything to stop it. Did the state invite the error? It doesn't matter, though, because double jeopardy is a U.S. constitutional requirement, and the state can't wire around a U.S. constitutional requirement with a state procedural rule like a red bow tie, or like a written information, or a written indictment. The state has the burden here of showing that that judgment, the contempt judgment, didn't count as jeopardy. Ms. Estevez was clearly, from the record, you can look at clerk's record around pages 67 and 68, clearly the case was, at the very least, about her committing a DWI while on bond. There was no evidence of any other violation of the conditions of bond. The only reason the DWI while on bond was a violation of the conditions of bond was that it was a crime. The elements of the violation of bond were the same as the elements of the DWI.
I thought there were allegations of several other offenses during...
There was no evidence of that, yes. There was no evidence of any other...
But there were allegations of, I believe,
yes,
8 other
absolutely.
offenses.
And that's a really interesting question, because now what happens when Ms. Estevez files a double jeopardy habeas in one of those cases? She's been acquitted of those because the state talked about them at the hearing, and there was no evidence of that. And no evidence is an acquittal. She has and Brian Garner says to pronounce it the American way. I don't know what the American way is, but autrefois acquit. Autrefois acquit.
That's American?
No, that's the French way, because I don't know what the American way is. Maybe you can tell me what the American way is, Judge Newell. Autrefois acquit. She's got a jeopardy bar, autrefois acquit. I've already been acquitted of these other allegations. If this hearing was about those as well, which the state says it was, I take them at their word. The Court of Appeals said that there was no evidence of the DWI because an information isn't evidence. And so Ms. Estevez has an autrefois acquit double jeopardy claim on the DWI as well.
How is the information that was submitted into evidence and not objected to not evidence?
I think it is evidence. I think it is evidence. I think it's legally insufficient evidence, but that claim hasn't been raised. It was the Court of Appeals that said that's not evidence, and they did that because that's what the state said in their brief in the Court of Appeals. I think that's a facetious argument, honestly. The judicial notice was taken, and things that judicial notice is taken of are evidence. And the court took judicial notice, and it was a prosecutor who said that this thing had happened. It's evidence. It's not great evidence, but it's
I
some
have another
evidence.
question for you
course.
about your argument about the conditions of release. How is that not similar to what we do in a motion to revoke, where you have a number of things in your motion to revoke, which could include an offense as the basis for the revocation. Then you have the new charge, the DWI charge. So you have no double jeopardy issue. So isn't the real issue what happened, whether the contempt order was void or whether the court had jurisdiction after their power?
It's an excellent question, and first of all, the answer is that in the motion to adjudicate or the motion to revoke, the person is actually being punished for the underlying offense, not being punished for the new law violation. So you could revoke somebody's probation, preponderance of the evidence standard for the new DWI, and then prosecute her for the new DWI. And jeopardy wouldn't be implicated because the punishment on the motion to revoke was not for the new DWI, first of all. Second, the question of whether the judgment was void, according to this rule of decision, which is that the state can't wire around the double jeopardy claim, it has to have been void for some reason under the U.S. Constitution. And so it's the state's job here, it's their burden to show somehow that this judgment was void, not just under the Texas rules, which I think it probably was void under Texas's rules. Now,
But what was she punished for?
she was punished for DWI. So
No, she wasn't punished for DWI. She was punished for contempt, and that was the condition of her bond, is what I understand.
yes, but she's not punished for the new law violation. She's punished for the DWI, which is incorporated as a condition of bond.
Wouldn't that
And-
be true in every time there's a revocation? You know, we had you out on bond after
No.
a armed robbery, and we said, don't commit any murders.
And
You committed a murder, and now we're gonna revoke you on your armed robbery.
no, because a revocation of bond doesn't trigger double jeopardy. Contempt, however, does. And I wanted to wait until rebuttal to talk about
When you
this.
say contempt does, what do you base that on?
Dixon.
I'm kind of curious.
Dixon.
I mean,
Dixon, which the state
yeah,
doesn't
let me
even-
just interrupt you for a second.
Sorry?
I just find it unusual because I've never seen Bennett held in contempt picking up a new offense. Normally, the remedy is just to revoke their bond.
Oh, right. No, it's a crazy procedure, and there are politics behind it.
Where does this happen?
This was Court 16 in Harris County, and it was happening for a while, and it's not happening anymore. It's not happening
You
anymore.
seem so relieved.
It seems like an unusual procedure.
I put a lot of work into making it not happen anymore, and I'm happy that I stopped it.
You mentioned Dixon, but Dixon was a very fractured opinion.
No, it wasn't. Not Dixon. Foster was a fractured opinion. The whole court agreed on Mr. Dixon's case, which is on all fours with Amarillyz's case. That is, the show cause said you violated your conditions of bond by committing a new law violation. And if you look at the underlying opinion in Dixon, the D.C. Court of Appeals opinion, which I've put in my notice of supplemental authority, if you look at the underlying opinion, it doesn't look like the show cause mentioned exactly how the bond was violated, just like this case. And what Justice Scalia held in Dixon, and what the whole court agreed with, nobody disagreed on Dixon. They disagreed on Foster. Foster is an entirely different case. They happened to be decided together. But in Dixon, the whole penal code was incorporated by the bail conditions, as it is here. And the violation of the penal code bail condition was treated by the U.S. Supreme Court in Dixon, and there's no authority to the contrary.
Here's my question.
Yes, sir.
The contempt proceeding is held by the court. The state really is not a party to that. And the court could circumvent the state's desire to prosecute somebody by simply holding them in contempt for picking up a new offense. And how do you explain that?
So there is a case in my materials in which, and I think it's the district court in Dixon, says, look, if the state didn't want this to happen, they could have just asked that it not happen, that we put off the contempt. The state did nothing of the sort here. They presented the evidence. And I want to get into why that's unseemly at best, but I'll let my colleague.
Just one question before you sit down.
Yes.
And so I'm trying to clear up some confusion. I'm seeing that there was an allegation that the defendant committed a crime and/or engaged in conduct resulting in his arrest. Is that same language also translated to the judgment for contempt in that same way? Is there a vagueness? Is there any question in your mind that the judge found that he committed a crime, or maybe that he might have, in the alternative, done something that might have made him subject to arrest for a potential criminal offense?
The only thing that there was any evidence of that might have subjected Amarillyz, she's a female, to arrest was the DWI. The information also alleged an open container violation. That's not an arrestable offense.
Whether you've committed acts that subject you to arrest is kind of a different factual inquiry than are you guilty of the crime?
Sure, I understand, and I think it's intended to be. I think it's written to be, we don't have to prove that you committed the crime. We just have to prove that you got yourself arrested.
You can see how that concerns me in light of the argument you're making about double jeopardy and.
Sure. Well, the court found that she had committed the DWI in the hearing. The court, so we don't have that issue in this case. The court didn't say, well, I don't find that you committed the DWI, but I do find that you engaged in some other conduct. But there really is no other conduct that could have resulted in her arrest. The elements of conduct that might have resulted in her arrest are, you committed DWI. Imagine if a witness had come in and testified, and the witness had said, well, I found her driving and she wasn't intoxicated, and I arrested her. Well, she wouldn't have engaged in conduct that could have resulted in her arrest. She was just driving. So it's only the fact that that the police thought she was engaged in something that was a crime that made her subject to arrest. I've deliberately split my time half and half because I want to hear what the state says when they try to meet their burden of showing that this judgment was void under the United States
We're all looking
Constitution.
forward to it. Thank you.
Thank you.
Spoiler alert.
Mr. Presiding Judge, may it please the court. John David Crump from the Harris County District Attorney's Office for the state of Texas, the respondent in this case.
First question out of the box. Is this a common practice in Harris County to hold people in contempt for picking up offenses while they're on bond? I've never heard of it in my entire career.
Judge Richardson, no, it's not. I can tell you that once my division got involved, in addition to Mr. Bennett getting involved, this stopped. And that's actually kind of the genesis of how this occurred. This was happening in Court 16. I believe that this court, in another case, Ex parte Warren McGee, had this issue before it as well. That was a summary reversal of the Court of Appeals on other issues, a jurisdictional issue, I believe. But it's similar of a case. There's some important distinctions, but they're similar. And I believe there's another one.
Does the jurisdictional ruling in that case affect this one?
They're similar. Well, I'm sorry. Let me take a step back. No, I'm sorry. The jurisdictional ruling in McGee dealt with, I think it was they just dismissed the appeal outright. It wasn't a jurisdictional issue on the underlying, correct.
Based on the wise advice of the appellate section, they put a stop to it.
Yes, I don't want to take complete, because Mr. Bennett certainly played his part as well. But that's how a lot of this happened. And that's actually how that happened in this case, is bringing all this up to that court. The court eventually was doing this and then recognized that its show cause order was so defective as to basically be void. And that's kind of what this case at this stage in front of this court is about. Because the double jeopardy questions that I believe Mr. Bennett was getting about whether this can be double jeopardy, are you looking at what was alleged in the show cause, those weren't even addressed by the Court of Appeals. The Court of Appeals did not address that. They just found that the original show cause order was void, and therefore, because it was void, because it was a nullity, the petitioner was not actually placed in jeopardy.
Who gets to make the argument that, that an order like that is vague, is too vague and to be void?
Well, Judge Yuri, I think that it depends on...
Does the state have constitutional rights? I'm asking you that.
The state does not have, generally speaking, constitutional rights are against the state to protect individuals from the state. But I would say it depends on what the ultimate conclusion is. And that's the distinction between void and voidable. So if something is void, and this is black letter law, it can be attacked at any point by anyone. And this is how this usually pops up in habeas proceedings, collateral attacks on something. You see this also in sufficiency claims against protective orders, where they say the underlying protective order wasn't sufficient. In that case, those are voidable claims. You waive them in the original trial court, so you can't bring it up again. But they always try and pigeonhole it into voidness, and then courts usually dismiss it out of hand, say you can't do that.
But if this had been an indictment or an information that was left out an element or something, and the defense didn't object to it, it wouldn't be void. So, I mean, it seemed kind of unfair.
Well, Judge Keel, I think that's true to a point. So you take a look at, I think the most recent case that this court dealt with was Jenkins in 2018, when it was trying to review the sufficiency of an indictment. And there are certain things that are an indictment. And there still, even after the adoption of Article 5, Section, or the amendment of Article 5, Section 12, there's still things that are not an indictment. The point here is, even if you were to use the test to determine what an indictment is, this show cause order would fail that resoundingly.
And yet the state pursued prosecuting her for this contempt on this order, right?
Well, so the mechanics of that were that the state did represent the state in this hearing at the behest of the judge. So the judge, and you see this when you're reviewing the record, the judge discusses how the judge had made the order and issued the order. I think he talks about it in terms of, I've refined my order based on what you, I believe he was talking to Mr. Bennett, have told me about where it's deficient. So this was the judge, primarily the actor there. But I'm not going to say that the state wasn't, the state did participate in this. I think you don't have the same sort of state action, though, as if we had brought the indictment. We had sought a grand jury, decided to file a criminal information, for example. What we did was we entered in the information, and the judge made their determination off of that. And so I think that as far as the state's involvement in there, yes, there is some state involvement, but I don't think that changes the analysis whether it's void or voidable, because it has been consistent throughout the jurisprudence of this state that the thing is a nullity. Going back at least to 1979 with the Supreme Court, they say that it's a nullity. It's as if it never existed in the first place. And so you see that as compared to a case like, I believe it's State versus George, where it's an Article 113 case about the waiver of jury trial. And there you didn't have the state agreeing to the waiver of jury trial. And so the issue is, well, was that person put into jeopardy? And the answer was no, because the original tribunal didn't have the authority to conduct the proceeding in the first place.
A period of time in the state when juveniles to be waived into the adult system had to have specific findings. And we had cases of people that didn't have those findings that had been in prison for 20 and 30 years. And those were void, right? It would have been void. So those people were never in jeopardy, though they were serving time in prison?
So I think, for example, I think you're referring to Ex parte Moon, and so I can tell you that Moon didn't have those findings, and they weren't in jeopardy. And in fact, we just retried Cameron Moon not that long ago. I think this past summer. Based off of that. Because the question is whether the court had jurisdiction in that case. In that case, the district court didn't have jurisdiction over the offense because it hadn't been a proper waiver. I know that this court has since sort of retracted Moon and certain requirements there.
But I'm asking, assume they hadn't, what would the double jeopardy implications be of having been transferred to the adult system, tried, convicted, and sentenced, and having served the sentence?
So
Jeopardy?
Well, so the question is whether you were placed in jeopardy in the first place, and if the district court in that case never had jurisdiction, then they weren't placed in jeopardy. I understand the implication.
So they've served their sentences.
Right, and in that case, if they are subsequently convicted, then they are, in the same way that an appellate reversal can say that your original trial wasn't good enough, you can still get credit to that. But the fundamental point, and I understand that your greater point about serving the sentence, et cetera, but it doesn't change the fundamental legal issue, which is that court never had jurisdiction. And this is how strong jurisdiction is.
Well, I want to ask that, so like, what is it about the show cause order that made it so defective that it didn't deprive the court of jurisdiction, or the court never gathered jurisdiction, compared to say the limited circumstances where an indictment is so defective that it's not an indictment? Like, I think the one example is they don't even name the person is for an indictment. So what is the corollary to that for this show cause?
Yeah, I think the other example is if the date of presentment precedes the date of offense.
That's right.
I've, unfortunately, when I was in the trial court, ran into that. So I think since Article 5, Section 12, yes, this court has recognized that there is, in order to get a void indictment, then you are looking at a much higher level. I would say that the things, okay, I would answer this in two ways. First, I think that there's just the basic level of requirements for a show cause under constitutional principles, and then I think if you were to liken this to an indictment, and I think that's the closest analogy that we have, why it would fail even as an indictment. Because
But she did object to it, right?
Your Honor, Judge Keel, I think she objected to it. I've been struggling with how to characterize this, and I believe Mr. Bennett alluded to this as well. She objected to it. There was a statement by the judge of, okay, she objected to the timing of it. I think specifically that she wasn't afforded the right amount of time. And I think Judge Jordan in response said something akin to, okay, well, I'll hold her in custody and then we'll proceed once you've had enough time, which I think was over the weekend. And so her attorney at that point withdrew his objection. I don't think he waived.
The court gave him like an option, right? Either
It was-
the client's going to stay in jail.
It was, to borrow from the last argument, it was conditional, either or. But Judge Newell, to return to your question, so in order to have a valid show cause order, you need to allege the order, reasonably specific order, you need to allege how it was violated, and you need to allege a willful, culpable mental state. And this actually bleeds into whether this is an indictment. None of that is here. There's not even the allegation that she would be facing criminal sanctions. As Presiding Judge Schenck, you admonished the person earlier today that she would potentially be facing confinement or criminal sanctions. That's a requirement, but I don't even think we need to get there because this, and I believe Mr. Bennett agreed under Texas law that this is insufficient. I believe that we disagree about the implication. I would say that if it's insufficient to do that, then she was never.
The thing I'm wrestling with is sort of if the show cause order is deficient, like, for example, get this back, when you get a reversal on appeal because of the process of the appeal, it is something dealing with something in the proceeding itself that ends up being a problem. And so that doesn't violate double jeopardy if you go back and try the person again. So is this a problem with the show cause order that's something that needed to be remedied? Or is it, how do I distinguish between this is something in the show cause order that needs to be remedied versus something that never invoked the trial court's jurisdiction?
So I think my response is kind of enmeshed with the way that contempt orders have been interpreted consistently for about 50 years, which is to declare that they're void. And this court has said that in those sorts of cases where it's a nullity, it's like it's.
Does it turn on whether the defendant asked for it?
No, I would say that's I believe where Mr. Bennett and I in our briefing disagree, and the crux of it is if it's void, then it doesn't matter.
Void ab initio.
Yes, void ab initio.
Isn't the double jeopardy guarantee one of these just simpler, light on, light off rules for the public, not so much for us nerds, right? I mean, I'm in jeopardy or I'm not in jeopardy. And when I'm staring at a judge and I'm told I got a problem and I may be confined, and then I hear that I am, later when I hear, well, I know that happened, but that really didn't happen, right? How do you explain that in a way that's consistent with the intentions of the framers and having a double jeopardy clause in the first place?
Well, so I think that's delving into the actual analysis. So forgive me if I go into that as well.
Let me push you forward, because I've heard enough. Let's say I'm not with you on there wasn't jeopardy attached from a proceeding that went to a conclusion. She lost, looked bad, but you said was void. But isn't it possible under Blockberger that she had two distinct problems? She made a promise to a judge that she breached, making the judge angry, and then she violated a penal code section. That is what Judge Parker and I were talking about earlier of you're out on bond, you're not supposed to commit any more armed robberies, you don't commit any murders, and I let you go. You made a promise to me when I let you go that you weren't going to commit any armed robberies or murder people, or I was going to make you serve a long sentence for what I let you go off of the first time. Now you've gone and done something else. Isn't that a better argument for your side of there's just not a double jeopardy bar here at all?
So I think that's certainly an argument that we've made in the trial court. It's certainly an argument we made in the Court of Appeals. The problem and the reason why I'm hitting so hard on voidness here is because the Court of Appeals didn't address that issue. So even if you do agree that this isn't void and that she was placed in jeopardy, there's still that second, I think as you've alluded to, there's still that second portion of are we even Blockberger precluded out? Obviously the state's answer would be no, but
Why?
that's something that the Court of Appeals didn't address.
Why? Why is the state's answer no?
Because when you're doing a Blockberger analysis, you're looking at the elements of the offense and you're comparing it to the elements of the offense, right? You've got, let's say that let's make it easy and just say two identical offenses, right? So let's say DWI. Elements of DWI are you operated a motor vehicle in a public place while intoxicated. Easy. So those are your elements of the offense. We have two charging instruments that allege, let's say that they're the same date. So let's make it super easy. And that is probably going to be a problem unless, I suppose, if you got out on bond and then drove all intoxicated again, but then you start looking at the elements or the evidence that was adduced at the proceeding. Now, why that's a problem here is because you have a show cause order that's basically saying, hey, you did a thing, and that's it. That thing being you did something and you got arrested or charged. There's nothing there to compare to. To return to Presiding Judge Shank's question about the order.
Who's culpable for the fact that it lacks specificity?
Well, I think
Upon whom do we put that burden?
I think that the burden would be, regardless of whether it's the judge or the state. I mean, I'm the one up here arguing, right? But the implication from that is the real question, whether it's void or not. And if it's void, and like I said, I believe Mr. Bennett agreed that under Texas law, this would be. And I think that using the analogy of something like State versus George, where you have a statute, a Texas statute that governs the way of jury trial waiver in that particular case under Article 113, and this court said no. The court didn't have the authority to do that. I think if it's void, then it's void. She wasn't in jeopardy. Now, if this court disagrees, that's when this court would remand it back to the Court of Appeals for an opportunity for the Court of Appeals to do a double jeopardy analysis.
Have to remand?
I
Is it a purely legal question?
So I think that, yes, I would say that the question that was granted was on the voidness one. I think I could certainly, that was the question I addressed, I should say.
That'll be up to us, I think.
I'm sorry, well, of course, it would be. But I think that generally, whenever there's an issue that was not addressed by the Court of Appeals, even if it's a question of law, the practice has been to remand it back to the Court of Appeals to allow them an opportunity. They didn't get to that threshold, or they didn't get past the threshold of, was this void?
Is the state stopped from saying that this is void since they relied on this during, I mean, you relied on the action of the judge for her to be given this probation?
I would push back on the reliance on her being given this probation. I think if you look at the record of the hearing, this was, the state was there, the state did participate, but this was largely the judge going through, and
So
yes,
you-
we submitted we submitted the information, but I don't know if that addresses your question.
I wanted to ask, so I guess that from a basic level, there was an order that the trial court had entered that the person violated, and that's what led to the habeas corpus, or the show cause, right?
Conceptually, yes.
Yeah. So why is it the judge lacks authority to enter or hold someone in contempt for violation of their order?
Well, because that comes back to whether the show cause order can, but let me go foundationally here.
Okay.
When you're dealing with a crime, you're dealing with something that has violated a penal statute. Everybody knows what it is. When you're dealing with a show cause or contempt, it's basically judges making up the offense at that time, right? We've got this order, and you violated.
You should have done a thing.
You did a thing. But it's basically judges acting to create an offense in a moment. Now, that offense is based off of a prior order, sure, but there are certain, in the same way that an indictment is supposed to give notice, that's one of the main reasons we have an indictment or criminal information. That's what the show cause order, and because you're dealing with types of, for lack of a better term, I'll call it an offense, but types of conduct, types of enforcement, whatever you want to characterize it, that is fairly ephemeral. Outside of that order, it requires a greater level, and that's why the courts have interpreted it to be void and not voidable.
You participated in the hearing. Did at any time the state say, hey, we don't want to be here, we don't want to put on evidence, you know, this is proceeding the wrong way, and now you're here before us saying the judge shouldn't have done that, but you were the one that was presenting the evidence. So what are we supposed to do with that?
Presiding Judge Schenck, I see I'm out of time. May I respond?
Reluctantly, yes.
I think, again, I've likened this to indictments, and I would liken this to the fact that there was that period of time in the 70s and 80s and into the early 90s where defendants were coming for the first time after having participated in a proceeding, and they were able to say that something was void. I don't think that mere participation is going to change the fact, and it certainly doesn't change the fact about whether it's void or not. And with that, request that this court affirm the lower court's judgment.
Thank you very much.
Thank you.
Presiding Judge Schenck, you asked about making the judge mad. Is there an offense of making the judge mad, right? The contempt was actually making the judge mad.
Breaking the promise.
Right, and Dixon answers the question. The state didn't brief Dixon because Dixon answers the question. Dixon is on all fours, and Dixon is Dixon and it's Foster. In Foster's case, the conduct both violated the conditions and also, with another element added, was an offense. But in Dixon's case, which was the unanimous decision, in Dixon's case, the conduct was only a violation of the contempt order because it was criminal conduct, and it was the same criminal
If
conduct.
you held him in contempt or her in contempt for something other than the DWI that was part of the agreement, we wouldn't be here, would we? In your
No,
opinion?
right, no, she tested positive for alcohol,
Okay.
right? No, that's,
Do you agree with the state that?
no. Oh, I'm sorry.
Just hear me out. Hear me out.
Yes, you're.
That the Court of Appeals addressed this case from the perspective of deciding that the order was void and so it never had any effect at all, versus addressing it as the question of whether there is an actual jeopardy violation here, right? And I mean, it seems like you're answering one question, which is an important question, is there a jeopardy problem? And the state is answering another question. And then, of course, if we go back to what we granted review of, I think that Mr. Crump suggested that the question we agreed to answer went to the voidness question. And so I'm struggling with that a little bit because maybe, let's say hypothetically that we might agree with you about the jeopardy, but we've granted review of another question potentially, and I don't want to take up too much.
I got
Go
it.
ahead, go
I've
ahead.
got it. The Court of Appeals opinion is terrible.
Okay.
It's sloppy, it's got misspellings, it's got errors in it, and so they don't really give a good reason. For example, they say no evidence, but clearly there's evidence. But the question for this court is, the de novo question is this a double jeopardy violation? Simple as. Mr. Crump took issue with my saying that this is indisputable. This is indisputable. It's indisputable, and it's indisputable because of Dixon, which again the state didn't brief, and also because of two other Supreme Court cases. Ball is one of them, and Ball was about an indictment being defective and still jeopardy attached. Now Ball's really interesting because in Ball there were 3 defendants, and one of them was acquitted. Other 2 were convicted. The 2 who were convicted appealed. The Supreme Court found that the charging instrument was defective, and the government went back to charge all 3. And the Supreme Court said, okay, it's fine to charge the 2 because they appealed. Oh, shoot. I'll get it. One of you said, I think it was you, Judge Newell, talked about, but both of you, talked about an appeal. An appeal allows a retrial, of course, because the defendant's consenting to the retrial, which is not what we have here. But the 2 defendants who had appealed could be retried because they had appealed, but the guy who'd been acquitted, even on the defective indictment, couldn't be retried. That's because jeopardy had attached. Jeopardy had been detached or been waived for the 2 guys who appealed, but Ball stands for the proposition that even where the indictment is defective, that jeopardy attaches. Remand is not necessary because of Dixon. The court can look at Dixon and can see that Blockberger is satisfied when the contempt order incorporates the entire penal code and there's an allegation of violation of a particular penal code section, just like this. It was Judge Newell who had asked about the appeal. He can be retried because of the consent. There are 2 possible U.S. constitutional objections. I didn't hear the state talking about any constitutional problem with the contempt judgment. The 2 possible objections are the 5th Amendment and the 6th Amendment. 5th Amendment, due process, we know that can be waived. Right to double jeopardy, right? That's the problem. The 6th Amendment requires that the defendant be notified of the nature and cause of the charge against him or her. She was notified. If she wasn't notified in the show cause, she was notified when the state presented its evidence, because it was after that she said that her lawyer said, okay, we'll proceed. At that point, when he decided, okay, we'll proceed, he already knew. Not only did he have notice of the nature and cause, but he'd seen the state's entire case. So there's not a 6th Amendment problem. There's not a 5th Amendment problem. The state hasn't proposed any other sort of U.S. constitutional problem. And so we're talking about a red bow tie. Now, do we agree that the bow tie wasn't red? Yes. However, we waived the red bow tie. The state talks about how it's void. Presiding Judge Schenck, you asked about juvenile cases. The case is Hong, H-O-A-N-G. It's 872 Southwest 2nd, 694. I think we both briefed it. Hong would turn out differently today. Because in Hong, the district court did not have jurisdiction over the juvenile, and so was allowed to be retried on cases that he hadn't tried to reopen. Outcome would be different today. And what that proves is that we have to follow US constitutional rules in deciding double jeopardy. Because it doesn't make sense that the same case with the same facts, the same procedures would come out differently in Hong, I don't know how long ago it was, 25 years ago, would come out differently today on double jeopardy than then without some Supreme Court change in how double jeopardy has happened, is how double jeopardy works. The only thing that changed is the red bow tie. That the state changed the bow tie rules for juveniles so that now you have to object to being prosecuted in adult court, and so Hong would come out differently today. Illustrates that we have to follow US constitutional rules because that's the bedrock, right? That's double jeopardy. Why we don't say double jeopardy unless no red bow tie. We say double jeopardy. Earlier today, somebody talked about the state playing fast and loose with words. This is a really interesting thing for me, and I think if there were nerds on the court, they might appreciate this. We have for decades misused the word void. A contempt judgment is void in the sense that it's subject to collateral attack. Void doesn't mean void ab initio. Void means, it's a term of art that means subject to collateral attack. The court can look at...
Including when it's a subject matter jurisdiction issue?
That
So-
would mean it's voidable. Voidable, yeah.
We think, right, the common use of the word is voidable, but this is a term, let me get with you in just a second, please. But it's a term of, void is a term of art that means subject to collateral attack. Look at Rhodes v. State, which is 240 Southwest 3rd, 882.
Collateral attack forever.
Subject to collateral attack, yes, forever. But that's not a constitutional principle. Because under the US Constitution, you could lose your right to file habeas within a year. That's the Anti-Terrorism and Effective Death Penalty Act. By Texas procedural rules, sure, except for laches, right? So subject to collateral attack, except for laches. Ex parte shields is another case from this court where this court talks about void being subject to collateral attack. There are others as well. It's the appellant's burden on collateral attack to show that the judgment is not valid. Okay, so jurisdiction. Jurisdiction exists. Jurisdiction, and there are this court's cases saying this, jurisdiction is something that the legislature gives to the court. The charging instrument doesn't give the court jurisdiction. The charging instrument invokes the court's jurisdiction. And what Article 5, Section 12 of the Constitution says is that the charging instrument gives the court jurisdiction over the cause, which is not subject matter jurisdiction. Subject matter jurisdiction exists regardless. If in Nix, this court gives the example of lack of subject matter jurisdiction. For example, a county court that hears a misdemeanor involving official misconduct. That's a lack of subject matter jurisdiction because the legislature said no subject matter jurisdiction. And sure, in theory at least, that's something that's not forfeitable and it's not waivable, but under the US Constitution and under the US Constitution, you can waive the Fifth Amendment rights, you can waive the Sixth Amendment rights. That's not a US constitutional principle that the invocation of subject matter jurisdiction, which is what the charging instrument does. So look for the words invoke, subject matter jurisdiction.
Is there a distinction to be drawn between authority and jurisdiction in this case? The trial court's authority to do what it did versus the trial court having jurisdiction, subject matter jurisdiction?
I think so.
Okay.
I think so. I think the subject matter jurisdiction is Government Code 21.001, which is contempt. And I think maybe the authority lacked the authority to do what it did because bail conditions can't be enforced by contempt. But that's a red bow tie, right? So Mr. Crump says, oh, it's void. No, that's a red bow tie. That the U.S. Supreme Court doesn't care. The U.S. Constitution doesn't care whether the bow tie is red. The U.S. Constitution cares whether this person was actually in jeopardy. And then there might be some US constitutional exceptions to that, but none of them apply here.
Thank you for your argument.
Thank you. We pray that the court reverse the judgment of the Court of Appeals and render a judgment in favor of Ms. Estevez. Thank you.
Appreciate the very fine lawyering from both sides. It's fun to hear it. Thank you. We will now stand in recess.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.